All good things must come to an end, and those ends have beginnings of their own. In Florida, the divorce process as a lawsuit begins with what's known as a divorce petition. A divorce petition is a legal document written by one spouse and served to another spouse. The petition must give the reason for wanting the divorce, usually that the marriage is irretrievably broken. A divorce can be filed in Florida if at least one spouse has lived there for 6 months or more. The petition must also be filed with the circuit court where one of the spouses resides. Also in Florida, there doesn't need to be any period of legal separation before a petition is filed. If someone wants out, there's nothing stopping them from getting the ball rolling. If you receive a divorce petition, don't panic. First, in Florida, you have 20 days from when you are served to respond. This will give you some time to think about it. Second, don't be upset if it seems that the petition asks for everything in the kitchen sink. It is common for petitions to ask for a lot because it is hard to ask for more later on. The most important thing to remember, if you intend to contest the divorce, is to respond by the deadline. If you don't, then your spouse may file a motion for default. If you are defaulted, the court will generally grant everything the petition asks for. When you respond, you should go through the petition and say in writing whether you agree or disagree with each thing that it says. Those written answers must be sent back to the filing spouse, and copies must be made for court and for use in the hearing. The case would then proceed to the discovery phase, in which you make financial disclosures to your spouse and the court. So start collecting any and all of your financial records, including deeds and tax returns. If children are involved, a more delicate handling of the process may be required. The court usually orders mediation in these situations. In general, though, it is best not to involve children in the proceedings at all. If you don't want to contest the terms in the divorce petition at all, just formally say so in the answer. Florida law allows for a simplified divorce process if both parties are in agreement and several other conditions are met. Those conditions are, first, both spouses must agree that the marriage can't be saved. Additionally, the couple cannot have any children who are minors, and the wife cannot be pregnant. Each spouse must also be willing to forego the rights to court hearings and appeals, and neither can want alimony. The couple must have agreed on how the assets are divided up and how any debts will be paid, along with being mutually satisfied with the court-approved financial information provided. If all these apply, the only things left are the signing of the petition in the clerk's office and a mandatory final hearing that is really just a formality. Divorce can be a hard road to travel, and more than a little scary. Legal U can make it easier. Legal U always has a free, easy-to-use form for responding to a divorce petition. Legal U, you can do this.